All right, we're talking about the phases in a criminal trial. We're past the jury trial. The attorneys have given their closing argument, and now the case goes to the jury. That's called jury deliberations. And what happens is the judge will read the jurors' instructions about the law and how to analyze witnesses, the facts, the evidence. He'll tell them only consider what you heard in the courtroom. Don't Google anything. Don't look on the internet. Don't do your own independent research. And the jurors now go to the jury room, which is usually in the back of the courthouse. They have their own bathroom and their own table, conference table. They sit around a table. And the first thing they usually do is select a foreperson. A foreperson is like the leader. They don't have any more votes than the other 11 members, but it's somebody that helps kind of like direct the conversation and the voting, if you will. So the foreperson will be elected. The jurors then will deliberate, which means kind of debate the case. There's no particular procedure for that. It's however they decide to do it. For example, each person in the table, they could go around the table and each person could talk about what they believe the evidence has shown, the defendant guilty or not guilty. Because remember, up to this point, the judge has instructed the jurors not to talk about the case with each other or anyone. So imagine a trial that lasts 2 weeks. They're watching this evidence. They're not talking about this case with each other or with anybody in the world. And so this is their first time to talk about the case. It's probably very exciting. Some juries take votes at the very beginning. Hey, let's get an initial vote, how everybody votes, guilty, not guilty. And a lot of times on juries, there's going to be one or two strong personalities that sway the other jurors to their point of view, whether that's guilty or not guilty. Now in California, the jury has to be unanimous. That means all 12 have to agree on the verdict, whether it's guilty or not guilty. Otherwise, it's a hung jury. Now, in the process of debating, the jurors might want to say, they might, for example, debate, what did that witness say? We can't remember. I thought he said this. Well, I thought he said that. Well, they could ask the judge to bring in the court reporter who takes a transcript of the entire testimony, and the court reporter will read verbatim from that transcript to refresh the jurors and so they could remember exactly what the witness said. They also have the exhibits in there. They're also allowed to ask the judge questions. Hey, judge, can we vote like this, or does the law apply in this manner? What will happen when the jury asks a question is they'll send it over to the judge through the foreperson, and then the judge will talk to the attorneys. They'll debate whether the judge, how he should answer it. It's ultimately the judge's decision. Then the judge will basically answer the jurors if he feels or she feels it's reasonable to do so, or the judge could say, I can't answer that question. Once a verdict is reached, if a verdict is reached, now a hung jury is considered a bit of a win for the defense because the prosecution has the burden of proof beyond a reasonable doubt. So if a jury hangs, a lot of times they'll come to the judge and say, we're hopelessly deadlocked. We don't know what to do. There's 2 people that are not voting with the rest of us, with the other 10. What should we do, judge? And the judge will say, go back in there and try to reach a verdict. And then they might come back and say, we're still deadlocked. And the judge could say, go back in there again and try to reach a verdict. In fact, the judge could even bring the defense attorney and the prosecutor out to re-argue the case, to do another set of closing arguments to convince the jury as to their point of view. Now, the defense is usually objecting to this because a hung jury is kind of a bit of a victory for the defense. Even though they don't get the not guilty, it requires the prosecutor to retry the case now and bring in the witnesses bring in the evidence. So the defense could usually strike a better deal once the jury is hung. So they're objecting, hey, we don't want any other arguments. Judge, we don't want the jury deliberating longer. They might not tell the judge that, but they're hoping that it's going to come back deadlocked. And I'll tell you one story in particular. It's kind of amusing. Is me and my friend were discussing a third attorney who had done a murder trial, and the jury was hopelessly deadlocked, and they were ready to come back as a hang, which would have been a bit of a victory, a moral victory for the defense. Well, the judge ordered the defense attorney and the prosecutor to re-argue their closing arguments, and lo and behold, sure enough, once they did that, the jury came back and found the defendant guilty, and he was convicted and had to serve 25 years to life. Well, the friend who was telling me about this case said, you know, if that ever happened to me, where the judge said, you have to come re-argue this case, I would check myself in the emergency room and tell the judge, I can't go because I'm in a medical emergency. I only say that to illustrate how important a deadlock jury is for the defense. And if there is no deadlock, the jury reaches a verdict. They write the verdict on a form, give it to the foreperson. The foreperson gives it to the judge, and the judge reads the verdict. But those are jury deliberations, very important part of the criminal proceedings.